Minister. Senator Madigan.
Thank you, Mr President. My question is to the Attorney General, Senator Brandis. Attorney, in 2012, the Gillard government amended the Family Law Act in a number of ways. This included expanding the definition of family violence beyond its traditionally understood meaning of physical or sexual violence, requiring courts to prioritise the need to protect children from family violence, so defined, over the interest of the child having a meaningful relationship with both parents, while removing a requirement the parties found to have lied to the court pay the legal costs of the other party. While perhaps well-intentioned, there is gathering evidence that in combination the effect of these changes has been to provide an incentive to parents involved in family court disputes to make false allegations of parental abuse. Can the Attorney please inform the Senate of any plans his office has to reform the family court jurisdiction?
The Acting Leader of the Government in the Senate, the Attorney General, Senator Brandis.
Thank you, Mr President. Well, Senator Madigan, that's an extremely important question, and I want to thank you for it, and I want to thank you for your interest in it. I can tell you, Senator Madigan, that the Australian Institute of Family Studies is currently evaluating the way in which the Family Law Act deals with family violence as a result of the 2012 amendments. That report of the Australian Institute of Family Studies is due in August of this year, and of course the government will consider it with great care and consider in particular whether any shortcomings in the 2012 amendments, having been identified, require legislative attention. As well, Senator, in October of last year I made a reference to the Family Law Council, and I asked the Family Law Council to consider the issues of the jurisdiction of the family court in the care and protection of children, and how the jurisdiction of the family court and state and territory children's courts intersect, with a view to changing the jurisdictional boundaries of those issues which, of course, in particular include family violence issues which affect the interests of children. I asked that the Family Law Council provide me with an interim report on that matter by the 30th of June, in other words, 7 days hence, and I expect to receive the Family Law Council, I should say, and I expect to receive that interim report from the Family Law Council then, and I will, of course, brief you on it, Senator Madigan. So those are two very important inquiries that are shortly to report. The Australian Institute of Family Studies, that is looking specifically at the matter, the definition of family violence, which is of concern to you, and the Australian Institute of the Family Law Council, I should say, which is looking at the jurisdictional issues bearing on the same issue. Thank
you, Attorney General. Senator Madigan, a supplementary question.
Thank you, Mr President. Attorney, while it is common for the family court to find that allegations of physical or sexual abuse made by one parent against another are unfounded, those who lie to the court in this way are almost never prosecuted for perjury. Given it is virtually impossible for a court to achieve a just outcome when one party goes to such lengths to mislead it, why is more not being done to deter this sort of behaviour?
Attorney General.
Well, Senator Madigan, I know that this is also a very, very important and difficult issue. Of course, to state the obvious, perjury is a crime. Perjury is a crime, but you're quite right when you say that very commonly, and not just, by the way, in proceedings in the family law jurisdiction, perjury, witnesses perjure themselves. They're found by the judge to have given unreliable or untruthful evidence, and very, very commonly they're not prosecuted. So the point I'd make to you, Senator Madigan, is that this is not exclusively a problem for the family court. But of course, if a witness does give unreliable evidence, if a witness does give evidence that the trial judge considers to have been untruthful, then that, of course, is likely to lead to findings against them, certainly findings against them in relation to any assertions of fact or allegations they might make in the course of giving that unreliable evidence.
Thank you, Attorney. Senator Madigan, final supplementary
question. Thank you, Mr President. One of my constituents, a family lawyer, recently said to me that he thinks the family court is now among the most hated institutions in Australia. Others have shared harrowing tales of bitter disputes that run over many years, costing hundreds of thousands of dollars and leaving all participants, that is, mothers, fathers and the children, seriously traumatised. Tragically, an all too common scenario involves these broken people going on to take their own lives. Attorney, can we stand by and allow this to continue?
Thank you, Senator
Is it
Madigan.
not time we
The time for
acted
asking
to
the
reform the
question has
family court?
expired. Attorney General.
Well, Senator Madigan, in your ultimate question you asked me, is it not time to reform the family court? I think because this is the jurisdiction that both affects more Australians than any other jurisdiction, and because in this jurisdiction every story is an unhappy one. At the end of the day, every story is an unhappy one. It's something that all governments must watch carefully and keep constantly under review. I might also say to you, Senator Madigan, that of course about 87% of family law matters these days are not dealt with by the family court but by the Federal Circuit Court exercising a family law jurisdiction. So the family court does not do most of the family law cases these days. It does the more complex ones and the appeals. But I've indicated to you, Senator Madigan, 2 reports that the government is about to receive, and of course we note your interest, we acknowledge and respect your interest, and we will keep the matter under review.
Thank you, Attorney